Eu ainda não para ficar à vontade. Só botar no mudo aqui. Não, deixa eu colocar aqui. A minha qualidade tá boa, não tá do som, pessoal? Eu desliguei bem, pessoal, só para te falar. Não sei se tu percebe, ela fica assim. Ela fica assim. E tem quantas pessoas, Camila, até agora?
Temos 10, mas.
Então já aceita, Camila.
Tá
Vou
ótimo, hein?
aceitar. Tá bom.
Hi, everyone. Good afternoon. Welcome to our webinar. Let's wait a few more minutes, 5 more minutes, and we'll see if more people will join so we can get started. So just for your understanding, the webinar will focus on the needs of your company's retention of international talent. If you are an employee or if you gonna be sponsoring your H-1B visa, that webinar will not focus on your needs. So I recommend you leaving and joining the webinar that we are conducting on Friday.
Someone put the link for the employees to join Friday, just for those.
Yes, we can share on the chat, Odila.
Okay, thank you.
And we
Hello,
also
Adila,
send
how are
the
you?
invitation to, we also send an invitation via email.
From my team received it, so just in case. Thank you.
Yeah, some of the information will be similar, so it's not gonna be like a waste of time, but some other information such as compliance and then backup options in case the employees are not selected in the lottery, that it might not be so useful.
Okay. So, thank you.
Okay, 2 more minutes, everyone.
Perfect.
We are conscious of your time, and we thank you for joining us today. But we will also record that meeting. So if you want to share with other people that work with you, your work colleagues, or someone that work with HR, and also companies that apply for the H-1B visa, you're going to be able to share this presentation too. All right, we can get started, Camila.
Okay. I'm gonna start recording right now. Okay, guys. Hi, everyone. Thank you for being here. It's a pleasure to introduce our speaker, an accomplished U.S. immigration attorney with over 13 years of experience navigating complex immigration matters, Bruna Frota. As the founder and principal attorney of INLG, she is licensed in both Texas and New York and works at the intersection of global talent and opportunity, advising multinational companies and high-achieving professionals across industries such as oil and gas, technology, and pharmaceuticals. Before founding NLG, she worked at leading firms including Ball Global and served as a corporate counsel for Santa Fe relocation. Today, in addition of leading INLG, she also serves as general counsel for the Consulate General of Brazil in Houston and for Tramontina.
Hey guys, their HRs and also companies that are interested in hiring foreign talent. This is the presentation for you. So as I said, we're gonna be covering the H-1B visa in general. Just explain to you the basics of the visa itself. We will cover the main changes that will most likely happen this year. The first one that will happen for sure is the change of the how the lottery will run. It's not gonna be a random selection anymore. It would be a weighted selection based on offered salary, and also we'll cover the instances where companies will have to pay the $100,000 fee, even though there is still hope that that regulation gets overturned by the courts, and then before we reach the H-1B lottery window, that fee will no longer be required to be paid. We'll cover also the difference between applying for a change of status and going through the consular notifications. What are the pros and cons of each option? the timelines and the process challenges. So we're going to talk about also the fact that some companies will try to raise employee salaries to increase the chances of selection in the lottery. However, if the job description and the minimum requirements to enter the position are not complex enough to justify that increased salary, that might the companies might run into additional problems, right? We will talk about the pre and post approval requirements that the company will have to go through to make sure that if there is an ICE audit, the company is bulletproof. And then we're going to finish with a section of questions and answers. So if you have any questions as I am presenting, please feel free to add that question into the chat. And then at the end, we will post the questions so everybody can hear my answers. And then if the question, for example, if the question has been already asked, so you don't have to repeat the answers all the time. So as Camila said, I'm not gonna talk about me now. I'll focus more on the on INLG. So INLG, it's our pride. We have been doing business as INLG for the past 7 years. We have a team of collaborators of around 80 people, and we are all around the globe. We serve clients from individual to multinational companies, and our expertise is work visas and green card for high net worth individuals, and as well as green cards based on professional achievements and for company sponsored green cards. And of course, we also work with other types of visas, but this is those visas are our type of expertise. Nowadays, we have over 400 cases, active cases that we are monitoring and working on. Now about the H-1B visa itself. So the H-1B visa is that type of visa that most likely you as an HR will hear during your lifetime, during your professional career. If you have an employee, for example, that you have just hired out of college, most likely the visa that you're going to be applying for that individual would be an H-1B. So you have someone with an OPT, you have someone working for you under a CPT, then the H-1B visa is the to-go visa. And why is that? The H-1B visa doesn't require any type of tenure with the company prior to the application of the visa. It is not tied to a specific nationality, and it allows individuals, of course, who have attained the equivalent of a US bachelor's degree to qualify for the visa. Now, once you have an employee, a potential employee or a potential employee that has those qualifications, right? It doesn't mean that if the employee has those qualifications that they will be qualified for the H-1B visa. The H-1B visa, it's also for positions that require at least a US bachelor's degree in a specific field. So you can have an employee that is overqualified for the position. You cannot have an employee that is underqualified for the position. And however, you cannot have a position, for example, for a technician or a position that requires less than a US bachelor's degree for the H-1B visa. So it's a combination of both what the company requires and what the employee has as far as educational qualifications. That same token, you cannot have an employee with a specific education in a specific major that is not related to the position that you are offering. That's not gonna work. You need a position that requires a specific degree that employee will have to meet those minimum requirements. What is the downside of the H-1B visa? One is for-profit companies, so usually private companies. The companies will have to go through a lottery system. And the reason for that is because the government has set aside a certain number of visas that can be issued per year, H-1B visas that can be issued per year. That number is 85,000, which 20,000 of them were set aside for individuals that have at least an advanced degree from a US university. And and then unfortunately, right? But fortunately for the US economy, even though you have 85,000 of visas available, there are more than 300,000 people applying for this type of visa. So that's the reason companies will have to go through that lottery system. The visa will only be valid for 6 years, meaning there is a max time that the employee will be allowed to remain in the US under this type of visa. And then also any time that that employee spent in the US under an L1 visa, that time that the employee already spent in the US will be counted towards the time of the H-1B visa, towards the 6 years maximum period. However, if the company or if the employee has already applied for a green card application while the H-1B visa is still valid, that employee will be allowed to renew that H-1B visa until the green card is issued. So the max out time is only will only apply in cases where the company or the employee haven't started the green card application yet. The other downside is that spouses are not allowed to work, only in very specific instances. But usually, general rule is that spouses are not allowed to work. All other benefits, as far as being allowed to obtain a social security number, work in the US, travel freely, the spouse will be able to study, the children will be able to study in the US, all of that is permissible. Going through the lottery system, right, you have to look into specific dates. There are some deadlines that you have to watch for, and then I'll cover those deadlines later on during this presentation. But going through the H-1B visa process will require three milestones. You have to go through 3 milestones. The first one is going through the lottery itself. And then once the employee is selected in the lottery, the company will have to file a petition with immigration through USCIS, United States Citizenship and Immigration Services, which is the immigration agency that oversees that type of visa application. And then once that visa, that petition is approved, if the employee is in the United States and required a change of status, that employee will automatically change their status to H-1B on October 1st, which is the first day of the fiscal year for H-1B purposes, for immigration purposes. So that's when the H-1B will kick in. Or if the employee is outside the US, that employee will have to use that approval notice that was sent by USCIS to then apply for a visa at a US consulate that it's of now under the Trump administration, a consulate that is located in the employee's country of citizenship or residence. Now, I think that's what's most important for many of you today, how the lottery actually happens, right? Until last year, the lottery was 100% random, meaning everybody will get into that lottery pool and names would be picked from that pool, right? Now this is no longer the case. Starting this lottery season, this selection will be based on offered salary. and then I'll talk about the odds of selection depending on the range of the salary or the salary level that you're gonna be under. What's the odds of election based on that? However, here are some of the deadlines that you're gonna be watching for in the upcoming months. The first one is the deadline to send names to immigration to be added to the selection poll. The first, based on last year's, right? So we don't have yet the actual registration dates. However, based on last year's, it's usually the first 3 weeks of March. So last year it ran from March 1st to March 18. So if you have already a list of employees that you want to add to the lottery, or if you are still finalizing that list, make sure that you send that list to us by no later than the 3rd week of February. So we can look at if there is any missing documentation from the employee or from your side in order to move forward with the registration for each employee. And remember that the selection, the adding the names into the lottery, we have to go through My USCIS, which is the USCIS portal. So we need to still create an account for you in order to represent you during the registration process. So that might take time, right, from both you and from our side. So that's why it's important to plan ahead and start putting together those names now, so we don't lose time and add those names last minute into the during the registration period. So once this registration period ends, based on, of course, last year's experience, within a week, immigration would be releasing the names that were selected. So usually by end of March, beginning of April, you should know the employees that were selected, and then at this point you're going to be able to work on the second milestone of the H-1B visa process, which is the filing of the visa petition with USCIS. Usually, based also on last year's experience, there was just one run of selection, one round. So once those 85,000 visas are already used by people that got selected in the lottery, then there is no more rounds. So the selection, knowing whether that employee was selected or not in the lottery, will end when we receive a non-selection notice. However, based on the current political climate and what Trump is doing with or making it harder for people to apply for the H-1B, we might see a decrease of number of applications this year. So we might not have those many applications as last year. So the chances of maybe having a second round might increase, and the chances of being selected in the lottery might also increase. Not counting, not based on last year's lottery, but the year before that, there has been always a second or third round of selection. The first year that I didn't see a second or third round of selection was last year, all right? Once we submit the registration online via My USCIS, we need to make sure that there are no typos, no any mistakes on the number of the tax ID, the names of the employee is correct, date of birth, nationality. And now what we're gonna have to also add to that registration is whether the employee will be added to the advanced degree cap or the regular cap. That was already the case before, but we also have to add this year what's going to be the offered salary or the range of salary. plus what's going to be the SOC code that the employee will fall under. So the SOC code is basically the type of job classification that this employee will be classified under. So if you have, for example, an employee that has a degree in electrical engineering, for example, most likely that employee will fall under the electrical engineering or the electronics engineering category. So this is a selection that we'll have to, that choice of SOC code will be made by us based, of course, on the job description that you're going to be sharing with us. And then, in addition to the SOC code, we also have to state what's going to be the work location, and then what's going to be the level of the wage that the employee will fall under. So this is going to be based on work location, because salaries will vary based on work location, and as I said, complexity of the job itself. So we're going to be adding those additional information, so the government will be able to make the selection based on that. What you need to watch for is, just remember, I spoke about the H-1B being a very popular type of visa because it's a catch-all type of visa. A lot of people would qualify, but you're going to have people that are working for you under an L visa, and then you want to extend that person's ability to stay in the US, or even getting the H-1B visa. So the person is going through the green card process and being able to extend their stay in the US under the H-1B visa, which is a benefit that is not offered to L1 visa holders. This is the time to talk to us, because you might not be able to extend, for example, to change from an L to an H-1B for someone that is already in the US with an L1A visa, for example, which gives that person 7 years of stay in the US. So that person might have already maxed out the time to qualify for an H-1B. That's the time to talk to us as well. This time, during the registration process, we don't deal with the employee. This is a process that will be conducted between us and the employer. Okay, so employees, I know that they will be super concerned or super anxious to hear news about the registration period. And then what we do, once the registration is submitted, we send an email to each individual stating that their names were added to the lottery. So that helps you, HR, to keep their nerves calm until a decision is finally made. So as I was explaining in the beginning, in order to qualify for an H-1B, that individual and also the position must require at least the equivalent of a US bachelor's degree in a field of education that is related to the position. And so when I talk about a US, an equivalent to a US bachelor's degree, that you can use the equivalence of an educational level degree, such as a bachelor's, a master's, a doctorate degree, but you can also add, and you can also combine experience with education, or just use experience in case that individual's education is not related to the offered position. For every 3 years of experience, you have 1 year of educational requirement. Meaning, if you have an employee that only has, for example, the equivalent of a high school diploma, that employee will need to show at least 12 years of progressive experience in that specific field of expertise. So, and that experience, as I said, must be progressive. So if someone has had the same position for the whole 12 years, that person, the company that conducts the education evaluation, will most not likely be able to issue an education evaluation for that individual. So as I said, to qualify for the H-1B, you don't necessarily need someone that has an actual bachelor's degree, as long as that person has enough experience or education combined with experience to get an equivalent to a US bachelor's degree for that person. Again, the field of education, the field of expertise must be related to the offered position. And the way that we look at it is, I know that in some cases, you're going to have a combination of different types of field of educational expertise that the person might have in order to perform the duties of a position. So, for example, you might have a position that requires that would allow someone that has a degree in law, a degree in business, or a degree in economics, for example, which in practice in the past they were not considered similar. But under the new regulations, which were released the beginning of the last year in January, which is the H-1B modernization rule, you can have a position that requires fields of education that were not traditionally considered similar to still qualify for the H-1B visa. So that's something that we can look it up for you and make a determination, but we usually use the Department of Labor's database to determine whether those fields of education are similar and they will pass the scrutiny of USCIS. If the employee qualifies for the advanced degree cap, we need to make sure that it's not just any US university that a degree in a US university that will make that individual qualify under the advanced degree cap. That university has to be a nonprofit, and then also has to be accredited by the US Department of Education. We look into those two requirements when we are looking whether that individual qualifies for the advanced degree cap, but we also try to get confirmation from the actual university if they have experience from other employees also being added to the advanced degree cap. And the beauty of the advanced degree cap, as I said, just because there are visas that were set aside to those individuals, the chances of selection are much higher if you go under the advanced degree cap poll when compared to the regular cap people. This year is going to be the first year that the government will look at the employee's salary to determine whether the odds of selection for that employee it's going to be higher when compared to their peers. As I said, when we initiate the H-1B visa application for you, we'll look at the employee's job description. Then we'll look at what's the minimum requirements to enter the position. Then we'll look into what's the offered salary and also where the employee will be working at. After that, we will look into the Department of Labor's website, which is called FLAG, and look at the specific job classification, as I said, the SOC code, under that specific work location, and look at the different wage levels. So every occupation will have 4 different wage levels. So level 1, of course, is for the entry positions. Level 2, you're gonna have mid-level employee. Number 3, more of a senior level. And level 4, you are looking to someone senior to managerial level, executive level. So usually the positions that qualify for the H-1B visa are positions that the job zone, the SOC code, falls under job zone 4. So job zone 4, we say the minimum requirement to enter position is a bachelor's degree. So if you have a position that requires only a bachelor's degree and 0 experience, that position will follow under level 1. But if you have a position that requires 2 years of experience, then you would go under level 2. It's a position that requires 3 to 4 years of experience, you are looking to level 3. And then if it's more than 5 years of experience, you are looking into level 3 or 4, and so forth. Same thing goes if the position requires a master's degree, for example, you're gonna look into level 2 to start with, and then it will adds up or bump it up as you add more experience, minimum experience for the entry into the occupation. So this is just an illustration that was done based on the number of applications that were submitted last year. So if the number of applications remain the same, which as I said, I don't believe this is going to be the case. I believe the number of applications will decline. If you have an employee that falls under level 1, the chances of selection are just 15%. In the past, as I said, everybody would go under the same pool of candidates, and the chances of selection for everybody was about 27 to 30%. And I'm talking about the regular cap, right? I'm not talking about the advanced degree cap. So under the regular cap, everybody would have between 27 and 30% of chance of selection. Now, even if you were level 1 or level 4, so everybody would be equal. Now, under this new calculation, level 1 individuals will only have 15% of chances of selection. Level 2, 31%, so it goes back to the previous rate of selection. Level 3, 46%, so it increases. And then level 4, 61%, which is mostly double of chances of selection when compared to the previous year. Remember that I said that the company cannot bump up the salary and not change the complexity of the job duties. So if you have an employee that the job duties reflect someone that would be an entry level individual for an entry level position, and then you offer a level 4 wage, that H-1B petition might get stuck and denied. So the government will look into fraudulent mechanism that the companies will conduct to deny petitions. So just make sure that that wage that is being offered reflects the level of expertise and the level of complexity of the position. Why it is important to plan in advance. As I said, the window to submit those applications is very short, just 3 weeks. And now we have to work with a lot of information to make a decision on what's the best SOC code to include into the registration. So it takes time. Just make sure that you get in touch with us so we can get started on that application right away. And why it is important to plan in advance, and why it is important to plan now before the registration is submitted. Just because, as I told you, the salary and the SOC code, the work location, they will all matter when later on the H-1B petition is filed. So if you send, for example, a job description to us that is very basic, but that salary is under a level 3 or level 4, that's the time before we submit the registration to talk to you about a potential request for evidence or even a denial, a notice of intent to deny in the future when the H-1B petition is filed. Same thing goes with the employees' educational background and experience to make sure that the education evaluation company will be able to deliver an education evaluation that it's beneficial to the process. Now, the other hot topic is that $100,000 fee that Trump decided to implement. Of course, the release was last year, right? It was an executive order that was released on a Friday. Then on a Saturday, everybody was just unsure if whether you had to return to the US or not to pay that $100,000 fee. But then later on, we got more information about it. So that 100,000 fee will only apply to those that will file an H-1B petition for consular notification. All right, I will repeat. Just to those that will file H-1B, the H-1B petition for consular notification. Remember, we have to go through the registration process first. Once you are selected, once the employee is selected, then we move forward with the filing of the H-1B petition. This is the time that we're going to be selecting in the form I-129 whether that employee will be filing for a change of status or a consular notification. So that's what's going to determine whether you are mandated to pay the $100,000 fee. If you are in the US with a visa, with a work visa or a visa that allows you to stay in the US until it is time to file the H-1B petition, you should consider remaining in the US or returning to the US at least before March. So you are in the US by the time you have to file your H-1B petition. Just bear in mind that, let's say you come back to the US with a tourist visa or a student visa, remember that there is a 3-month rule that we apply. So there is no preconceived intent that the government can apply to you saying, oh, when you came to the US with your F1 visa, your intention was already to change your status to an H-1B, and therefore you didn't qualify for the F1. So we want to follow that 3-month rule, so the preconceived intent is not an issue for you. So when I talk about returning to the US in March, just consider that you are coming back to the US with a work type of visa. But if you are coming back with a tourist visa, as I said, or an F1 visa or a visa that doesn't allow dual intent, I would comply with the 3-month rule, and then you should come back to the US by now, February, no later than the beginning of February. So, and if you, as I said, you have to plan as far as I wanted to consider or not paying that 100,000 fee for that employee. So it is time to, if you have an employee that has a visa that is expiring before filing the H-1B petition, it is time to think about getting a new type of visa for this person inside the US, or even extending the status of this person if the person is already here until it is time to apply for the H-1B visa. If you have an employee that entered the US with an ESTA, which is the electronic authorization for that applies only to individuals of certain countries, those individuals cannot change their statuses in the US. So just bear this in mind. It's not just because that employee is in the US with an ESTA that they will qualify for a change of status. Other than the ESTA, of course, if you have an employee with a TPS, or if you have an employee that is under a refugee status or asylum status, it's time to talk to us so we can look into whether they would qualify for a change of status inside the US, so they have to go through the consular notification, and then you can evaluate if it makes sense or not to add that employee to the lottery pool. Costs associated with the H-1B visa process. So you're gonna have the cost associated with the registration step, and then you're gonna have costs related to the filing of the H-1B petition and also the costs with the actual visa application at a US consulate abroad. The higher fees, of course, would be from USCIS. It would be when you file your H-1B petition, so the second step of the process. You are looking into attorney's fees, government fees, premium processing fee, which is now being raised on March 1st from 2,805 to 2,965, just for your knowledge. Then you're gonna have the MRVV, which is the consular fee, and then translation and education evaluation. Okay, this is what you can expect. I have been asked whether this one, the 100,000 fee will remain, right? So there are some cases that are litigating this $100,000 fee. So there is a chance that the fee will be overturned and will not apply, at least for this cap season. So there is a chance, if the only reason that you are not adding employees to the lottery pool is the fear of paying the 100,000 fee, my recommendation is to go ahead and add those people to the lottery pool anyways, because you can always, of course, if the $100,000 fee doesn't go away and you don't want to pay for that, you have the option to walk away and not move forward with the H-1B visa petition filing. So the difference between a change of status and consular processing, and everything that I'm gonna explain here doesn't apply to Canadian individuals, because Canadian individuals are visa exempt, right? I'll talk about the Canadians later. So here in the US, you're gonna have with an H-1B, you're gonna have three main documents that you should carry and pay attention to every time you are in the US or you travel to the US. The first one is gonna be the actual H-1B petition that is approved by USCIS. This is the document that tells you and the government and the company how long you are allowed to remain in the US and work for this company. The second document is your I-94, which is a document that is usually issued by CBP, right, Customs and Border Protection, when you enter the US, or by USCIS when you file for an extension of status or for a change of status. And your third document will be your actual visa sticker, the visa stamp that goes into your passport. That document is valid for travel purposes, meaning to travel to the US. Once you are inside the US, the document that will cover your legal stay is your I-94. The visa is valid. The duration of the visa is based on reciprocity. So it's based on your country of citizenship. And it's valid until either the expiration of that H-1B petition or until the expiration of the visa based on reciprocity, whichever is earlier. Once you are in the United States, right, we are talking about here a change of status. So you enter the country with a specific type of visa. So let's say you enter the country with an F1 visa. And now the company will change your status to H-1B. So once you file that change of status with USCIS, you are receiving two types of documents, two of those three that I just commented. One would be the H-1B petition, and the other one is your I-94. By the time you travel internationally, you leave the US, in order to return, you're gonna have to visit the consulate to apply for a visa, okay? And as you know, depending on your country of nationality, now there are some travel bans, right? As of now, the majority of the countries, they will fall, the travel ban apply to green cards or to B visas or F visas, not work visas. However, we never know when the political scenario will change. So it might be that if you are outside the US and then that travel ban comes and hits your country of nationality, you might not be able to get that visa to return to the US. So as of today, my recommendation is to always look into whether you're gonna be required to pay the $100,000 fee and whether you can get stuck outside the US in case you leave in order to get your visa to return, right? So those are going to be the two main conditions for you to consider before making this decision as to whether you want to do change of status or consular processing. Once you file that H-1B petition, we have seen processing times ranging from a few weeks to almost 8-10 months. It really depends on how busy the USCIS officers are and also whether they are running additional background checks. So we still have cases, for example, that we filed back in May, June of last year under the last year's cap season that are still pending. So you just have an idea of how long it might take. You have always the option to pay the premium processing fee and receive a decision in 15 business days. However, just remember, I said that the calendar year for immigration purposes start on October 1st. So even if you have a petition, H-1B petition, that it's approved before October 1st, your status will only change on October 1st. So you have to consider, for example, traveling during the expiration of your visa and when the new H-1B triggers, right? You have to consider applying for your visa and so forth. So just consider the premium processing filing when you are looking into your travel needs and then the conditions and then the risk of getting stuck outside the US in case you are not able to obtain that visa. After USCIS approves your H-1B petition, right, and you want to go to the consulate to apply for a visa, you can apply for a visa 3 months prior to October 1st, right? However, you can only enter the US 10 days prior to October 1st with that visa. So also consider that when you are deciding between change of status or consular processing. How soon can the employee start working for the company? As I said, the H-1B triggers on October 1st. So if you have an employee that the H-1B visa was approved before October 1st, that status will automatically change on October 1st, as long as the employee did not leave the US, remained here, and the I-94 will be the same. If the employee's petition is approved after October 1st, that's when the H-1B status will trigger, and that's when the employee will be eligible to start working for you. So if you have an employee that it's not under your payroll, it's not someone that already has a visa that allows them to work for you, you're gonna have to wait until the H-1B is approved and after October 1st in order to employ this employee. You're gonna have to pay that offered salary within 30 days of entry in the US or within 30 days of the approval of the H-1B petition if it's for a change of status, and then 60 days if it's a change of status. Let me rephrase that. So 30 days from entry if the person is coming from outside the US, And then if the person is inside the US 60 days from the change of status approval or from the, in that case, when the H-1B petition is approved. However, I would recommend stick to the 30 days always. Even if you can postpone to 6 days, I would say 30 days is the way to go. So some issues that have to be addressed right now before we move forward with the registration process. One is whether that employee will have the education evaluation that corresponds to the minimum requirements for the position, and if that employee will have a criminal or immigration violation that would make them ineligible for the visa. So you might have someone that would qualify for the approval of the petition itself, but then later on, when that person goes to the consulate to acquires a visa, or it's here in the US and has a violation that would make them deportable, then that's the time to look at the risks and make the considerations if you want to go through that process or not, knowing about the risks. Time limit for the H-1B, again, just to refresh our memory, is for 6 years. Time spent in the US under an L1 will be counted towards those 6 years. But if you have a perm or an I-140 that was already approved, you can always continue renewing that H-1B indefinitely until the green card is approved. Some backup options in case your H-1B employee, your employee is not selected in the H-1B lottery. You have the E-1 or the E-2 visa, but that will only apply to certain companies and to certain individuals. So the individual will have to have the same nationality of the company, and the company will have to either have made a substantial amount of investment in the US or conduct substantial trade with the country of the company's nationality. You're gonna have the F1, right, which would be the majority of the individuals that will apply for the H-1B. Then, of course, under the F1, you have the F1, you have the CPT or the OPT as options in order to hire that employee. You cannot have an employee working for you with an F1 only without the proper work authorization. You have the E3, which is the H-1B version for Australians, right? So if you have someone that is from Australia, you add it to the H-1B lottery, that person is not selected, you can always pursue the E3 for that person. Same thing with the H-1B1, that's the similar version of the H-1B for people from Chile or Singapore. O1 for people with extraordinary ability. L1 for the ones that have worked for your company in the last 1 year, within the 3 years prior to their entry in the US, and the TN for Mexican nationals. They are similar to the H-1B, but the options for occupations are not as, the list is not as extensive as the list is for the H-1B, and of course the green card. So those are some of the options that you can explore. This is the illustration of how the H-1B process, that's the flow of how it works. I will not go through each of those bullet points, but the main milestones are initiating the case. We send a list of documents that we require from the company and the employee. We make all the appropriate evaluations. Everything is good. We create an account for you with MyUSCIS. We add the employees' names into your MyUSCIS account. You approve that registration, and then we submit the registration for you. We make the payment for you, and then we wait for USCIS to return with the name of people that got selected, and then it's time to work on the actual H-1B petition. One of the most important documents that goes with your H-1B petition is the labor condition application. And I'm going to talk about the labor condition application shortly. The labor condition application takes 7 days to be certified by the Department of Labor. So once we have that certification back, we are able to then file the H-1B petition with USCIS. If you are filing an H-1B petition without any dependents, like a change of status from H-4 for dependents, we can file that petition via my USCIS. Otherwise, we're going to have to mail that petition to immigration. Once we receive a decision, so that decision can be an approval, a denial, a request for more evidence, so a notice of intent to deny. We will have to respond to that request, and then once approved, if you file for a change of status, the employee will have their status changed to H-1B automatically on October 1st. Otherwise, that employee will have to go to a US consulate overseas to obtain the visa in order to travel to the US. Now, I would just emphasize some of the, or repeat myself with some of the points that I have raised during the presentation that you, as a representative of the company, you have to watch for to make sure that the government doesn't make a determination that you are submitting fraudulent documentation or information. The first important point is don't tailor the job description to meet the employee's educational level or experience. All right, so make sure that job description meets the industry requirements. The second point is the creation of the public access file. That goes along with the submission of the labor condition application. So the labor condition application is a contract that the company will sign with the Department of Labor, committing to pay a specific salary that it's above the prevailing wage for that specific SOC code in that specific work location for that specific wage level, or the actual salary that is being paid to other employees in similar positions. So that's the labor condition application. The public access file is a file that you need to make it public, and anyone that wants to see that file is allowed to do so. In that file, you're going to have the labor condition application, you're going to have the prevailing wage determination, which is where you got that minimum salary from. You're going to have also the actual wage memo, which explains how you come to the conclusion that that was the salary to be offered. And then the third document is the internal posting notice. So as part of the submission of the labor condition application, as part of the H-1B visa program, you need to notify employees in that same work location that the company is sponsoring an H-1B for that specific occupation, for that specific salary and for that specific duration in that specific location. So although the employee's name will not be on that internal posting notice, you have some clients that will say, well, if you put that a CEO, right, is being hired to work on that position, it's going to be very hard to other people not know that this person will earn a specific salary. So this is something to consider, right? Specifically for the employees that have high level positions, because other employees will have access to that information. Any change of salary, work location, job description must be reported to us before that happens, because that might trigger a need for an amendment of the H-1B petition. right? If the employee is just changing, for example, just getting a promotion to a higher level, but the position remains drastically the same, there is no need to file an amendment of the petition. But if you have an employee, for example, that is being transferred to work in a different department and doing different things, you're gonna have to file an amendment of this petition. If you have an employee that is just changing locations, but within the same metropolitan statistical area, you don't have to worry about filing an amendment of that H-1B petition and so forth. So that's something that you have to always keep us appraised of what's happening so we can advise you accordingly. The salary, as I said, you're gonna be signing that labor condition application with the Department of Labor, and you are committing the company to pay a salary that is not lower than what other U.S. citizens, green card holders, people in the local force earn with that similar professional experience, also in that work location, that same metropolitan statistical area. The employee will have to be paid as a W-2 employee. In some instances, we have seen cases where employees would be independent contractors and that would pass the scrutiny of immigration, but that's not my recommendation. The way to justify the employee-employer relationship is by keeping the employee as a W-2 employee. As such, you're going to be required to pay all FICA taxes and then offer the same benefits to that foreign national that you offer to other employees working in the US. So that concludes my presentation, and then I'll open the floor now and answer the questions that you have.
Hi, Bruna. We already have 2 questions. I can read it for you if you'd like, or I don't know which way you
please do it for me.
Okay, so the first question is from the question is, when exactly the employee will be able to travel outside the USA after receiving the finalized change of status approval notice?
For the change of status, right? Let's say you have someone that has an F1, this person is an OPT, right? And that person will be able still to travel back and forth with that F1 OPT. So let's say that person gets an approval of the change of status in July. So that person wants to travel from July, right, until, let's say, 1 week prior to October 1st. That person wants to come back to the US and not worry about having to apply for an actual H-1B visa. There is a rule that is called final action rule, meaning when he comes back to the US under this F1, technically that approval notice from July will trigger on October 1st because the final action that was conducted by USCIS was the actual validity of the I-94. So your question will have different answers depending on the person's individual situation. But I would say if you have someone that got an approval for a change of status, usually the safest route is not to travel abroad, right? Because you don't know, again, with all the travel bans that are happening, we don't know if the person will be able to return to the US or not, or if the person is not able to return, if the person will need to obtain a visa to return to the US, that person will not be able to return to the US. But technically, you are able to leave the US once that change of status is approved, but then you're gonna have to monitor very well when you can return to the US so you don't have to worry about obtaining a visa and getting stuck outside the US.
Okay, thank you. The second question. Sorry.
Yeah, regarding the Bruna's response, my question was mainly because of the $100,000. So let's say during the process right, before the person gets the approval, they cannot travel at all. They must stay put, right, in the US. So
the $100,000 fee, or even if they have to apply for a visa in the future, they don't have to pay that fee because the approval notice will have a note that says that the fee will not apply.
okay, so that's what, because so they have to wait until they receive the approval notice to be able
Correct.
to travel abroad.
Yes.
So after they receive that, they can travel abroad. However, they can only return before October 1st.
Correct.
A for me. All right, thanks.
Thank you. Okay, I have a second question. Okay. If my employee already has an H-1B and it's renewing it's this year while maintaining lawful status, and they decide to travel to Brazil to get the visa stamped in their passport, would the company still be required to pay the 100,000 fee, even though the original process was done as a change of status rather than through consular processing?
Yeah, so that person will not have to pay the $100,000 fee because it's not a new petition. So the $100,000 fee only apply to new petitions.
Thank you. We have another question. It's also from, can I pay my employee as W-2, but also as 1099 if he receives commission?
So as long as the W-2 payment reflects the salary that was offered in the LCA, that's okay.
Okay, so we don't have any more questions in the chat. So if anyone is wants to open their mic to ask something to our attorney, I don't know if you, Bruna Frota, would like to highlight anything else that you think is very important.
No,
So
I think everything. Oh,
we have
yes,
a
go ahead.
so we got some of the clients two questions, and one of them I believe you already answered. It's basics. It's going back to the $100,000 fee, but basically they're asking based on that new fee for consular filing. Would you think that that may actually improve the success rate for the lottery, or you don't think so? Because he also mentioned that it was better in 2025 than it was in 2024 as they increased the cost of the application from $15, I believe, or $10 to $215, right? So what he's basically asking for your opinion regarding that.
Right. I think some employers will be discouraged, right, to apply for the petition because I don't think it's clear yet to a lot of people how that fee applies. So I believe there would be a decline. So because there is a decline on applications, the chances of selection will be higher to those that apply.
Yeah, I think the other one you already mentioned a lot, like are now the change once you're selected, it's harder to get it approved now than before with this new government. I think you mentioned that a little bit already.
Yes, I would say that overall, yes, because the goal is to minimize legal immigration as well. So I believe so. It's gonna be more discretionary.
Okay, that was it that I got. Okay, if anyone has anything else, please speak up.
I guess not.
Right.
I will try to make a question with my.
Participating.
So you have
Yes.
a question, Oscar? You got a question?
Oh,
Yes, I'm trying to talk. I have a very bad voice today, but
That's okay.
so so for the TN visa holders. That they are working already as TN visa holders. So they apply for H-1B. Is any different rule for those?
No, they will. The only problem for them will be traveling outside the US, right? While the change of status is pending. Because if they file for a change of status, right? While
Correct.
the pending, that change of status will be denied, and then they will approve the petition for consular notification, and then the company will have to pay the $100,000 fee.
Okay.
But if they travel outside the US, they will have that H-1B approval notice. They can return, right, with the TN visa. But then after October, if they wanted to return after October, right, or if they leave after returning before October, they will have to get their visa, H-1B visa, at the US consulate to return. Does that make sense?
Makes sense. Thank you.
Would that $100,000 apply in this case?
Only if the change of status is denied. In case they leave the US before receiving the approval of the change of status.
Yes. Okay, thank you.
Thanks, everybody. It was a pleasure talking to you all.
Yes,
Thank you,
Very
everyone.
much, INLG.